Now coming to the topic of reliefs. Reliefs are of two nature. One is the final relief that you'll be seeking for your clients, and one is the interim relief that you will be seeking for your clients on the first day of hearing or the initial proceedings of your hearing. Final relief are in the nature of damages, instructions, writ, prohibition, certiorari, whatever. All those are the final reliefs that I'll be dealing in the next section. First, I'll explain or talk about the interim reliefs that we'll be dealing with. For an interim relief, as you'll understand that the respondent may not be there during the time when you're seeking reliefs, because you're often seeking ex parte relief without the opposite side being present, so that finally when the issues have been adjudicated, the parties are in a position to enjoy the decree of the court. For interim relief, the courts often deal with three tests. The first test is the prima facie case that you are able to establish. The second test is the irreparable harm and injury. And the third test is the balance of convenience. These three tests flow from Order 39 of the Civil Procedure Code, which are often applied to all sorts of interim reliefs. Now coming to the first test. The first test, where we say that the prima facie case is in your favor, the test that the court applies is to see, basis the submission that you have made, the facts that you have laid down clearly in your petition, that the court feels that yes, there is an issue that needs to be adjudicated. Two, that issue, once adjudicated based on your submissions, there is a possibility or a likelihood that it may be directed in your favor or ordered in your favor. Three, that the submission that you're making is convincing to the court that you have come bona fide and your interest needs to be protected. The second test that deals with the interim relief is the irreparable harm and injury. Now, to decide for a court to give you an interim relief, at that stage, the court is sitting with one-sided story. It is not that the respondent has given any facts. It's not that the trial is completed, the facts have been established. No, it is at a stage where a court is trying to accept everything that you're saying with a pinch of salt. And therefore, when the court has to give an interim relief, it feels necessary to first see, if I don't give that interim relief, can the relief in the final adjudication be compensated with monetary damages? Therefore, you have to establish a case that no, if you do not give me the interim relief that I'm seeking before you today, I will not be able to be compensated with the monetary damages you may give me at the end of the adjudication. Therefore, the terms used by the courts usually are irreparable harm and injury, which cannot be compensated by monetary damages at the end of the day. Third, the test that is applied is balance of convenience. The test of balance of convenience usually implies that if I have not been granted, so for example, an order which says status quo, that is, that both parties maintain the status as on date, the plaintiff or the petitioner would be put in a worse off situation and a greater inconvenience will be caused to the petitioner from what it is already there when he or she has approached the Honorable Court. And therefore, once the court applies these three preliminary tests or the primary test in granting interim relief, the court decides whether to give you the relief or the interim relief, such as maintaining status quo, giving you an injunction, attaching property, asking the other party to deposit money. You may say that the party or the respondent is not in a financial situation and ask him to do a security deposit. All these forms of interim relief can be granted by the court depending on the facts of the case and the satisfaction or submissions made by you on these three tests for interim relief.